Let me just first briefly introduce myself. My name is Schaerr. I practice law full-time in Washington, D.C., in significant part in the religious liberty area. I'm also an adjunct professor of law here at BYU Law School, where I teach courses on constitutional law and Supreme Court litigation and religious liberty advocacy specifically. And I'll introduce Mr. Antiedu in just a minute. I'm honored to join with all of you in this symposium, which, among other things, as you know, is celebrating the 75th anniversary of the Universal Declaration of Human Rights. As you know, that document was adopted in 1948 in the wake of a convulsive worldwide experience in World War II, and many of the nation's leaders decided that it was time to have a comprehensive declaration of human rights against which military and political rulers around the world would then be judged. And in my view, as a teacher of religious freedom law, Article 18 of that document is one of the most important provisions ever enacted or adopted by any kind of legislative or advisory body, because it calls for robust protection of freedom of religion or belief. So with that brief introduction, let me introduce Mr. Antiedu. He is a Benjamin Tachie, is that how you pronounce your middle name? Tachie Antiedu is a professional legal practitioner from Ghana. He's the author of a book called Reading the Law. Sometimes I wish my students would do a better job of reading the law. He obtained his LLB in 2014, his qualifying certificate in 2016, and was called to the Ghana Bar in that year. Besides his bachelor's degree, he also holds a master's in business administration and a master's degree in oil and gas law. A little afield from human rights, yes. But as those of you who are lawyers know, you have to have a way to earn a living, and then you have an avocation that you're passionate about or more passionate about, and that may be what Mr. Antiedu. And he's been working with the Parliamentary Service of Ghana for the past 16 years, and he's also been practicing law at the law firm of Gardi and Gardi in Accra, Ghana. So with that, Mr. Antiedu, we'll invite you to come to the podium and give your presentation, and then we'll introduce our other speaker. Oh, who just arrived? So that's that's quite all right. We have you seated over here. So thank you for joining us. Let me go ahead and introduce Mr. Butt, Mr. Salman Aslam Butt. I pronounced that reasonably well.
Absolutely.
Okay. Well, thank you. Mr. Butt has almost four decades of experience in corporate, commercial, and constitutional law. He is a senior advocate of the Supreme Court of Pakistan, a title conferred on the most experienced and seasoned litigators before that court. From 2014 to 2016, he also served as the Attorney General of Pakistan. And in that capacity, he was the ex officio chairman of the Pakistan Bar Council, the apex regulatory body of the legal profession there, and an ex officio member of the Judicial Commission of Pakistan. As Attorney General, Mr. Butt represented the government of Pakistan before the Supreme Court in several landmark constitutional and fiscal matters, including a successful defense of the 21st Constitutional Amendment. And maybe you could tell us what that amendment is when you speak to us. Additionally, he also represented the government of Pakistan in several international arbitrations. And so we are delighted to have both of our speakers with us, and we'll turn the time over now to Mr. Antiedu.
Thank you very much, Mr. Jane. I don't want to attempt the second name. Forgive me. Good morning, and a special appreciation to the organizers for this unique platform, and particularly to my co-speaker, a man of considerable experience and knowledge. And to the Ghanaian team, led by Mr. Richard, we so grateful for your warmest reception so far, and our former ambassador or current ambassador to Belgium. We thank you for your attendance. So permission to start. Yes, so we were given the opportunity to choose a topic that reflects the general theme. So I should have been expected to be here espousing the miles that Ghana has achieved so far in promoting and protecting human rights generally, and in particular freedom of religion. But there's an angle that may sound ironical, but I think it's for a good purpose. Thank you very much. So, yes. Okay, so the topic is freedom of religion in Ghana, to regulate or not to regulate. And the response will be clarified later stages. Yes, so Ghana, because that is the space within which this presentation is about. Ghana is a West African country, obtained independence in 1957, quite known for its democratic credentials and total freedom. We are about 30.2 million Ghanaians, and our wealth, the country's wealth, is generally of minerals and particularly gold. So Ghana is noted for that. But recently we have also discovered oil and gas and copper and other minerals. So until the arrival of the Europeans, Ghana was colonized by the British. Until then, we had our traditional religion, diverse forms of worshiping God through the path that the ancestors gave. So upon the arrival of the Europeans, we received a lot from them, good, bad, and evil. I think one good thing we received was in respect of Christianity. So that became part and parcel of our religious space until today. Okay, so continuation of that, more about Ghana practicing different forms of spirituality now. So now currently we have a good number of religious practices in the country, Christianity being the first, the largest, about over 70% of the population are Christians, but we have Muslims also forming a good percentage of over 13%, and the rest are traditional worshippers or followers. So the breakdown is there for further reading because of time. I wouldn't want to bother you with that. Okay, so a bit about statistics, about the composition of the various religious groups there for you. I spoke about a census that projected 71% of the total population being Christians. And in 2021, the same projection has been made. So now we come to the part that we're looking at, actually the law, what the laws of Ghana say about freedom of thought, conscience, and religion, with emphasis particularly on religion. But we see how we have reflected the UNDHR in our law in its various forms, and it's quite expensive. Okay, so I will take you through the Ghana law and see how it's linked to the Universal Declaration of Human Rights. Okay. So the relevant provision of our Constitution is found in Article 21, 1B and C of the 1992 Constitution of Ghana. Those who are abreast with the political history of Ghana, we've gone through a series of military regimes until 1992, particularly 7 January 1983 that we started a new breath of democratic regime which we have sustained up to today. So unlike our colleagues, we are over the 23 years of continuous democratic regime. Okay, so per the provision, the constitutional provision, it reads, all persons shall have the right to be freedom of thought, conscience, and belief, which shall include academic freedom. So at one point, one can look at freedom of thought, conscience, and belief as being one level that relates even to the freedom of religion. But more specifically, you have freedom to practice any religion and to manifest such religion. So we see a very important recent decision of our High Court that reflects freedom of practice of religion and the right to manifest or to practice and live it in a real sense. Okay, so just as I said earlier, our constitutional provision, which definitely if you want to do a critical academic study, will even go beyond what have been shown earlier, but of course is critically linked to Article 18 of the Universal Declaration of Human Rights, Article 18 in particular, on International Covenant on Civil and Political Rights and the Declaration on the Elimination of all forms of intolerance and discrimination based on religion or belief also recognize this right. So that's what I said earlier, that there's a very good link between the right, the freedom of religion and the UNDHR. Okay, so that's for our reading. Okay, so just as we understand, per the general presumption that when we talk about freedom of religion, then includes freedom not to even have any religion. And that has been strongly espoused by our Supreme Court generally, that the right to exercise any right also confers the right not to, exercise that right. And that extends to religion. In Ghana, this is entrenched, and I've illustrated that earlier. So just a repeat of the earlier statement. Okay. Now we come to the point of observation as a private practitioner and somebody who has been observing how the judiciary has been enforcing the freedom of religion in Ghana. I will talk about some few recent cases. I'll look at the good, the bad, and the evil. But the good one, of course, to be started with, and that's the case of the Rastafarian students. And then the High Court's affirmation of freedom of religion and the right to manifest same. In 2021, two students who applied to our one of our second cycle institutions called the Achimota Secondary School were refused. In fact, they were even placed per our school placement system. But when they went to the school, they observed that they were wearing dreadlocks, the Rastafarian hairstyle. And the school said no, they had to go and cut the dreadlocks because according to the school rules, which had been long-standing since the school was formed over 60 years ago, that you are to cut your hair to a very low level. So that will not admit of dreadlocks. And so the parents, the students involved, two of them, they were devastated, and their parents insisted that they would challenge the matter in court. So they went to the High Court of Ghana, and then the court made a bold pronouncement, and that is very, very important here, that the court reasoned that the school's decision infringed on the students' right to education on one hand, and particularly of their religious freedom. And I think that this is a major pronouncement, and it settled the matter. And I'm sure that going forward, this will be strongly upheld by all educational institutions. Then, having seen the good, we want to see the bad and the evil. And that is where the question that I posed earlier will make sense when we are talking about promotion of freedom of religion, then we are talking about regulation. Is that not a deviation? But the point is that Ghana, or in most part of Africa, we will say that we have a case of overprotection, because a lot of people, because of the absolute freedom of religion, a lot of people take advantage and in the cloak of religion do a lot of things and even infringe on the rights of others. And sometimes it gets pronounced, in some cases, deadly events happen. So the first one, which is quite recent, is one that we call God Papa the Greatest and Emperor Lupita case. There's a former pastor and a wife. They were first Christians. At some point, they faced a lot of challenges, and they reasoned that through the advice of their wife, that they were tired of God, and that God has not been helpful, so they will go to a different religion. And so they converted to a new religion. They have not described it so well, but at least there's a new religion they are following now. And to them, they had 3 children. One of them, the man, God Papa the Greatest, envisioned that one of them was possessed by a demon. And they agreed that they will kill the boy. If not, when he grows, he will give birth to more demons and harm humanity. So to them, they were rather helping humanity by undertaking such a practice. So definitely, they were. It was even their own confession that brought matter to the attention of government, and the security agencies took steps to, go through the legal process. So they are facing prosecution now, and there are a number of other cases. There is a case also against one Agrada Mama Pat, who on a televised advert, displayed huge amount of money. And then in the video, she's heard inviting everybody, her church members and anybody who needs money, to come to the church and come for seed money to go and do business. So a lot of people rushed there on the particular day. When they went, then when she saw the numbers, then she decided to first ask them to donate first, according to the day you were born. So in Ghana, we have the Kofi and Ama. If you are born on Sundays, for each day you are born, we have a name for you. So those who are born on Sunday, if you're a man, Kofi is Friday, which is Kofi. So those born on Friday, Kofi, and Ama on Saturday, they will start. So Kofi, those born on female born on Friday is what? Fia, they will start. Okay, so they went around, donated so much money, and then she changed the rule again. That now what she's going to do is that the days or those for the days who win, who contribute the highest, they are the only people who will be given the money. Yeah. So it created a lot of issues because we have, unlike most European countries or in the Americas, we don't have highly literate society. We have a good, considerable number of people who are not literate, and some of these things can easily catch their attention. And so, let me see. There are even other cases there. This particular one, of late, there have been proliferation of television stations due to the introduction of digital platforms. And so, we have traditional worshippers who even come and demonstrate their powers in doubling money or even conjuring monies. So they do that and give out contact numbers to be called by those who are interested in making money. So 2 teenagers in one of our peri-urban areas, Kaswa, went to see this man after the TV show or the advert. And they were told that if they could go and kill someone and bring the blood, that can be used for that. And teenagers, as they were, they also went. And even a boy in whose house they were, always eating, they managed, lured a boy to an uncompleted building and killed him. And when they were arrested and interrogated, that's when they confessed that they actually went to see a fetish priest who directed that that's what they should do. So these are many more, and these are recent cases, so there are so many that happened in the distant past, which all inform that we have a challenge, even in giving that free space for freedom of religion. And that position is also a matter that has been reflected in a Constitutional Review Commission report that was produced in 2019, that majority of Ghanaians agree that there should be some form of regulation. Some of us have thought that the religious groups themselves should be self-regulating so that you wouldn't have the temptation where government or politicians will come in and impose some restrictions that will harm the freedom that we enjoy now. But since there has been a failure on that part, the pressure is on government, of course, within the political space, for government to do something about it. And that is where this question of whether we should regulate or not regulate comes in. Okay, so following the recommendation of the commission, that's the Constitution Review Commission, that there should be a regulation, then it is the interest of democratic watchers to ensure that the regulation should be done in such a way that it will be minimal and will not go to restrict the practice of freedom of religion in Ghana. So the suggestion based on what has been said, we have two options here. One, by legislation, which possibly can be done, because the law generally looks at general exceptions to the enjoyment of rights in general, that for any right is subject to the public interest, and then for the protection of the rights of others. So I think that this comes within the domain where a law can be made to do that, but it should be in a very minimal and peripheral form so that it doesn't impede the practice. So the recommendation here is that the proposed law should be limited to registration of faith leaders, places of worship, the setting up of a religious council, which I in particular will endorse, that we limit that one to the religious leaders themselves, no government participation here, because of the general understanding that we should separate freedom of religion from the public life. And then there should be a body that will monitor some of the activities of these faith leaders. We have, and this is not new, because we have Christian Council of Ghana, which is an association of some Christian religion groups that have come together to self-monitor and to project common good. But I think that if it's broadened to be like maybe a religious council where they will self-regulate and make sure that the excesses that we have had will not be repeated. So generally, still talking about how the law must behave, and this is where I will also recommend that religious leaders should take the lead, so that it is their own prescription. They will know best what can be, can help them, and will not go to limit what they stand for. And we have also been cautioned by Professor Dateba, a former Supreme Court judge, trying to educate us about the boundaries within which such a law can operate, and that he's saying that definitely with the space or the kind of provisions that we have in the Constitution, giving total or some a greater freedom for religion, there cannot be any law that will limit people to particular religions, and then you can also not regulate how they should worship. But of course, dealing with other matters of regulation that will also oversee what they do is still important. So generally espousing the good that religion serves in society and the need for us all to protect this and to also while doing that, there is also a need to police the system in loose terms so that unscrupulous people will not manipulate or misuse religion for negative purposes. So I end here. Thank you very much for your attention.
First of all, I want to thank BYU for inviting me, and it's an honor for me to be present here and speaking before all of you. I would restrict my talk to South Asia, which is, as maybe you know, that is 1/4 of the global population, and it's a multitude of indigenized religious population with 2 nuclear states. We talk about freedom of thought, conscience, and religion, Universal Declaration of Human Rights, and we heard 2 very eminent speakers yesterday. And what I understood was that this declaration probably does not have a binding effect on the nations. Although it was passed unanimously by all, 16 nations, but it does not have a binding effect. And we lawyers, we normally do this. We hide behind technicalities. And one of the technicalities being that it has not been approved by the Parliament, and it does not have a legislative force to be binding, to make it binding. I personally speaking do not agree with this because we have voted, the nations which voted for it, it was the state which voted for it. It was the state which ratified it. It was not done by a simple government. And the state includes all the organs of the state, which is including the judiciary, the executive, the legislators, and everyone. So saying that this is not binding probably is not very fair. And we had such a situation in our Supreme Court. There are 2 conventions. One is the Convention on Conservation of Migratory Species of Wild Animal, and the other is the International Trade in Endangerment Species of Wild Fauna and Flora. The Pakistan government had our signatories to both these conventions, but again, there was no law backing it to enforce it. And I was then the Attorney General, and I took the objection before the Supreme Court that you cannot look into it because it doesn't have force of law. The Supreme Court did not agree. And the point which was made by the Supreme Court was the state cannot come up and today say that they are not bound by it. They are bound by it because they are signatories, they have ratified. You cannot go back on your word. So this is a little explanation to the binding nature which was discussed yesterday, and this is my view, and corroborated by the Supreme Court of Pakistan. The topic, I'll just come back to the topic and South Asia. In South Asia, we all used to live together before the partition of India, Pakistan, Bangladesh, and India. And all the 4 or 5 religions, like Hindus, Muslims, Christians, and even Jews, they lived together. They were neighbors. And there was religious tolerance at that time. and they used to participate in their religious ceremonies, and no problem at all. But I think, I personally see that this religious tolerance there's less and less religious tolerance now. And even a petty dispute between people of two different religions is made, such a hype is created, and I think the modern means are to blame for that also. In social media, is a petty dispute between and then little about India. In Pakistan, the state has been not the persecutor. They have always defended the minority rights. And we have a written constitution, and there are two parts I would refer to in today's discussion. One is our preamble, or it's an objective resolution. Objective resolution is like the preamble, but it has a little higher status than the preamble. And that provides protection to the minorities. I will read a few of the lines from the preamble. Wherein the principles of democracy, freedom, equality, tolerance, and social justice, as enunciated by Islam, shall be fully observed. Wherein adequate provision shall be made for the minorities freely to profess and practice their religion and develop their cultures. Wherein shall be guaranteed fundamental rights, including equality of status of opportunity and before law, social, economic, and political justice, and freedom of thought, expression, belief, faith, worship, and association, subject to law and public morality. Wherein adequate provision shall be made to safeguard the legitimate interests of minorities and backward and depressed classes. So this is the preamble, or the objective resolution. At one time, the judgments of the Supreme Court even said that the objective resolution, if there's a conflict between a constitutional provision and the objective resolution, the objective resolution should take precedent. But now, later jurisprudence which has developed has given the Constitution, the main Constitution, the higher level of higher level than the objective resolution. This is, in addition to this, we have the fundamental rights, which is provided in Part 2 of the Constitution of Islamic Republic of Pakistan. Pakistan, the majority of population is Muslim. We have a very, I think 96% are Muslims. I think some 2.5% are Hindus, and 1.5% maybe Christians, and a very, very minor of other religions, a number of other religions. But in the fundamental rights, we have given protection to the minorities, and I will show that how the state has acted in protecting the minorities. There are 3 articles which I will refer to in the Constitution, which specifically deals with the minorities' protection. I refer to Article 20. Subject to law, public order, and morality, every citizen shall have the right to profess, practice, and propagate his religion, and every religious denomination and every sect thereof shall have the right to establish, maintain, and manage its religious institutions. No person shall be compelled to pay any special tax, the proceeds of which are to be spent on the propagation or maintenance of any religion other than his own. The state shall safeguard the legitimate rights and interests of minorities, including their due representation in federal and provincial services. So these are the constitutional protections which have been provided by the Constitution, and any law or any practice which is in violation of these fundamental rights, which are Articles 20, 21, and 36, that can be struck down. And this is what exactly we saw happened in one of the cases. There is a Divorce Act for Christians, and that is dated 1869. And it provides for divorce only on the grounds of adultery. And that was the traditional ground only available for the Christians. But there was another ground added. When it was removed, one of the Christians came to the court and said that this is against my fundamental rights because he had some irretrievable differences with the wife and just they couldn't cohabit together. And the ground which was only left was not available to him or to her. The court struck down the order of removing that Section 7 from the code, the Divorce Act, and held that this would be discriminatory because the Christians in other parts of the world have the right of divorce under other grounds, but not in Pakistan. That would be discriminatory. And that, in addition to that, what they wrote was that it would be against the Again, this is a very celebrated case, and this, in our Constitution, there is a provision which is numbered as Article 184, and Sub-Article 3 of Article 184 gives an inherent power to the Supreme Court of Pakistan to look into any matter which is of public importance relating to breach of fundamental rights. So there was a suicide bomb in a church in Peshawar. Peshawar is a city in the northwest province, which we call Khyber Pakhtunkhwa province in 2013. Then the Human Rights Cell of the Supreme Court had received some letters where there being threats being given to the Kalash tribe and Ismailis in Chitral. This is again the northern part of Pakistan. The Supreme Court took notice on its own. So this was a question of public importance dealing with the breach of fundamental rights. Forced conversion and the bomb blast. I was then the Attorney General, and I remember that the Chief Justice took personal interest in the case, and all the administration of the West Province, the Northwest Frontier Province, which is Khyber Pakhtunkhwa Province now, was summoned in the court. They was sent to the Kalash and the Ismaili tribe in Chitral, and we were asked, the Attorney General Office was asked to supervise and see whether this threat, how much the threat is and how to mitigate this situation. And reports were submitted before the Supreme Court, and all steps which were required were taken by the administration to protect the people from Kalash and the Ismaili tribe. The church where there was a suicide bomb, certain recommendations were made by the Supreme Court, and I remember that there was compensations to be paid to them. Those were not enough. In fact, both the provincial government and the federal governments were asked to make substantial compensations to the affectees. And I'll just refer to some of the few lines from the judgment of the Supreme Court. Says that the term religion cannot be defined in rigid terms. The freedom of religion must be construed liberally to include freedom of conscience, thought, expression, belief, and faith. The freedom of conscience cannot be separated from the freedom of religion. The freedom of conscience is an individual right, whereas the right to religion has both individual and community-based connotations. Of all the provisions of the Constitution relating to minorities' rights, Article 20 is most significant, which is in the nature of an equal religious protection clause conferred on every citizen. And then certain recommendations were made, and those recommendations now, a commission has already been constituted by the government of Pakistan to implement the judgment of the Supreme Court, and report is to be submitted. Then there was another interesting case against, because as you have seen, the number of minorities is very, very minor, but still you see how the Supreme Court, which is part of the state, is taking interest in protecting the rights of the minorities. This was a case in which Hindus, they had a temple in a place called Kathas Raj, and that has become a very famous case in Pakistan. And there was a pond in which there was water, and that water was considered very holy by the people of following that religion. That pond dried, and the Supreme Court, the human rights cell, probably received some information, and they took notice of it. And there were 5 or 6 cement factories which were established there with the permission of the state, and they were also taking water by installing 12 to 14 tube wells in each factory. The Supreme Court issued notices to all those factories who had spent millions and millions of dollars in establishing those factories, because the area is such that the limestone and other raw material is easily available over there. Those factories were called, and they were told that since you are using the water so much that the water level has depleted, and the depletion is affecting the rights of the Hindu community. Those factories were asked to close all those tube wells. They had to upgrade their cement plants. Millions of dollars were spent. They were given 6 to 9 months to upgrade those plants. And as corporate responsibility, they were asked to ensure that all times the pond is full of water. So the state in Pakistan, I can say with some confidence, that has always protected the rights. But at the same time, I would confess, there have been violations, persecution, but those have been done by individuals or some individual groups. And the state has always looked at them and are always trying to protect them against those persecutions. There was another, there are certain laws, there were demands from Hindu families that the Hindu religious laws should be made, and so that the marriage can be recorded as other marriages are, and those all have been implemented on the directions of the Supreme Court of Pakistan. We have our neighboring country, India, which have similar provisions, although it's a secular state. We are an Islamic state, they are a secular state, and this is what their constitution also says. They have, I'm not, the time limit crossing it?
Take another minute or so, and then we'll invite questions.
Okay. So I'll just briefly say that they have the similar constitutional protections provided for the minorities. But unfortunately, the state has made laws which are discriminatory, which includes the Citizens Amendment Act of 2019, which provides for illegal immigrants, protection for illegal immigrants from all religions other than Muslims. All religions are protected, but only the Muslims, unfortunately, have been excluded. And there are some other also, which, with lack of time, I may not go into. And one question which you, sir, asked was regarding the 21st Amendment. That, too, relates to religion. Actually, what happened was, I think we say it was similar to what you faced as 9/11. Army Public School in Peshawar, that was a bomb blast, a suicide bomb blast took place, and hundreds of students died. And then these were all terrorist people who were, in the name of religion, they were carrying out these activities. Now, as we know that the trials of these persons becomes very difficult before ordinary civil courts or criminal courts, because they are threats. They are very powerful people. They are threats from these groups to the judges, and they can't do anything. Convictions become almost impossible. So we thought at that time to introduce the military courts, which can be used to try these people who are, in the name of religion, acting against the defense of the state, because they were attacking government buildings, government installations. And we, in fact, 3 times before this amendment, which we introduced, and introduced this concept of military courts for such persons, was struck down by the Supreme Court. But there was one silver lining over there. In those judgments, there were 3 grounds which were allowed in which the military courts can work for such persons. One was, they said the military courts are only for the discipline of the armed forces. The second was espionage. And the third was defense of the state. And these 3 things are universally accepted, because these army courts are universally the same. I think in the US too, they have the same. In England, they have the same. In India, they have the same. So we webbed our case around the defense of Pakistan, because these people did not believe in constitution. They were only in the name of religion attacking the government installations and causing loss to the state, to the property, in life, and absolutely the life was paralyzed in some areas. People could not go to their homes, and they were totally occupied and taken over by them. This proved to be very successful, and at the end I would say that I got the opportunity of meeting Mr. Eric Holder in Washington. And our meeting was for 30 minutes, but it went on for 2 hours, I think. And the only thing which we discussed was, how did you make these army courts? Because it was tested by 17 judges of the Supreme Court, and the judgment came 11-5. And I explained him everything in much detail than I have discussed here. And at the end, when I was leaving, he said, "Salman, I wish we had thought like this. Probably we would have avoided Guantanamo Bay." Thank you very much, and sorry I've taken more time. Thank you very much.
Why don't you stay here? Stay here, we'll ask questions.
Okay, please.
Let me invite another round of applause for our 2 excellent speakers. And I thought, so that all of you can see us, we have just a couple of minutes left for questions, and so I invite audience members to ask questions, and we'll let either of our guests respond as appropriate. Yes, sir.
I have a question.
Mr. Burton.
Following up on the notion that perhaps regulation is called for
concern that I've seen is that sometimes these religious bodies, even if they're the ones who come up with these proposals, can themselves become a vehicle for abuse. And that is, they make a judgment on what is religion and what is not religion, what is an appropriate practice and what is not. So my question to you is, has anyone thought through the enforceability if there were such an association of religious leaders or people who did not have a religion? What would the mechanism for enforcing be if they violated the code or the rules of that body?
Go ahead, please.
Follow up, just so we can do it.
Okay, that's fine.
Just if indeed, thank you for that question. And what happened in Kigali, I know that President Kagame, he has stopped these fly-by-night pastors. So I want you to relate it to this, and if indeed we can do it.
Okay.
Thank you.
Thank you very much, Senior Richard, for your question. Yes, our courts, particularly the High Court, has jurisdiction, supervisory jurisdiction over our administrative bodies. So this definitely will be an administrative body that will be subjected to the supervisory jurisdiction of the High Court. So whenever there's disagreement, but I have thought through about the particular expression of freedom of religion in Ghana, and we will not have the fundamental issue about what is religion, what is a religious conduct, and those things. Because whatever it is, you can broadly say that it's about freedom of belief, so that our interest is not in categorizing matters of belief, religion, and the rest of them. So whenever there's any disagreement or there's an abuse from the kind of structure that we have envisaged, then the High Court will act to determine what must be done. And I'm sure that Chapter 5 will holistically be analyzed and used to settle. So that fear should be allayed. And particular about how far we can regulate and whether we can stop certain practices. Of course, you look at our Local Governance Act, a lot of powers have been given. But when it comes to religious freedom and actions, then everybody is, stepping for fear of being labeled a devil. So everybody wants to be as clean as possible. That is why I have advocated that if we need such a structure, let it come from the people who practice. But there should be some understanding that they are equal, no matter your size or anything, just like within the universal thinking of countries, that no matter your size, population, we are all sovereign, so that collective views from even individuals who hold specific beliefs, their views will also be taken, so that when something comes from them, then it will be well reflected and it will not be a government directive, which is always seen to be problematic, especially when it comes to freedom of religion, because you allow the state more power, and then politics will come in, and politics will look at numbers, and then the religious groups with larger number may have a special take. Thank you very much.
Thank you. Maybe we can go over time for just another minute long. Does someone have a question they would like to ask Mr. Butt? Well, we'll take one more question for either of our guests. We'll adjourn, and will the two of you be available to stay for a few minutes here and just talk to people individually?
Sure.
Okay. Yes, go ahead.
I have a follow-up on the Ghanaian, the Ghanaian law. The concern is regulating some of the practices. And I guess my question is, why are existing criminal laws not sufficient? You used the example of the two who believed that their son was possessed of demons, and therefore they went forward and I guess killed him. That can be prosecuted as a criminal act. You don't need to regulate religious practice to resolve that problem. And it seems like getting into regulating religious practice is a very slippery slope. So why does existing law not solve the problem?
Thank you. Wonderful question. Yes, on that particular example, I also spoke further about the intervention by the police. The police and the security arrangement in Ghana have, a mandate over all these sectors, and they work. But we looking at a more proactive and preventive measures so that we don't wait till they happen. But there are some of them that are even difficult to describe as criminal, because they will purely say that we are exercising and manifesting our religious beliefs. For example, the Mama Part who invited people to come. This is my church. I didn't compel anybody to come to my church. But I think that if there are some overbearing bodies, not necessarily government bodies, they will be able to come out with some code, as was shared, that you need code of conduct, at least some level, whether binding or of some advisory nature, to govern us. If not, we'll have some of these things happening before the state intervenes. Thank you.
One more question.
I'll make sure to keep it short. I just wanted to thank both of you, and I had a question for Mr. Salman. It was an honor to listen to you and listen to you talk about the intricacies of law, especially from your experience. I just wanted to ask, from a legal aspect, or is there advocacy possible for states who are enacting discriminatory policies? You briefly mentioned about India at the end of your remarks, from an international law perspective or organizational perspective, or even individual states, what can be how does advocacy work in that way, or is that even achievable? I just wanted to ask that.
Well, advocacy would work. I personally always feel that these laws, there are two sets of laws. One set relates to the internal, where the state has to implement the laws, or the state has to provide protection, which is provided in the Constitution and the law. And the second set is where the state, when the state herself becomes the persecutor, then what do? Then we have this convention. And my view is that no one can hide behind, as I earlier said, behind the technicalities, and it can only be enforced by people or states which have influence in the world, and that influence need to be exercised to implement these conventions. We cannot just leave them, just pass them, ink them, and say, okay, we have a very nice convention, and fine, we leave it and we can't enforce it because it's not binding on us. Well, then you don't ratify it, you don't sign it, and then again there is discrimination where there are economic and political reasons come. There are countries which were recommended to be part of the CPC, and in the US, they were not put in as CPC because they were political and other consideration. So we need to, in my personal view, with utmost respect to everyone and with complete deference, that we need to have a standard. If it is so, it has to be so. If it is not so, fine, perfectly fine. But you cannot say that it has been recommended by the report to put 4 countries in as CPC, but we put 3, 4th for economic or political reasons we can't do it. I think probably that's one way of looking at it. Thank you.
Well, thanks to all of you for your questions, and as I mentioned, both Benjamin and Salman are willing to stay and ask questions or answer questions individually if you would like. But one more round of applause for them, if we would.